one instance of poor judgment. There is a really great review article that can be found on the Department of Labor website, and it looks at the difference between poor judgment and misconduct. And the author of it kind of has a sense of humor because he says, isn't all misconduct, doesn't that result from at least some poor judgment by the employee? But the argument for one instance of poor judgment, it can only be used if you don't have prior warnings for that same behavior, where you say, it was the first time I engaged in this behavior, it resulted in my termination, I shouldn't be disqualified from receiving benefits, yes, I made a mistake, I violated the company policy, I fell asleep at work, I was 15 minutes late, whatever the case may be. So you can argue, only one time, I should still be entitled to benefits. Another defense that I like to use is if it's a technical violation of a company policy, but it doesn't rise to the level of disqualifying misconduct. Not all instances of violation of company policies, even if they result in a termination, equate to misconduct. And we actually just received a decision, I want to say 2 days ago, that the ALJ found this exact thing. In that particular case, just because it's fresh in my mind, we had a claimant who failed to report that he was injured at work. He was a cleaner. He was cleaning, I believe, garbage cans, and resulted in, he had some soreness in his back. He didn't report it to his employer. The employer fired him and said, you didn't immediately report an injury. It's our company policy that all injuries, no matter how insignificant they are, must be reported to us. I think in this case they were very concerned about workers' comp claims. And he was terminated. The judge found that in this particular case, yes, it was a technical violation of their policy, didn't rise to the level of misconduct, and the claimant was entitled to benefits. Another defense that you can use is carelessness or ordinary negligence. So this would be, you made a mistake, you failed to place an order, you missed a deadline, you did something improper, you were just careless. Another good defense is a good faith and error in judgment or discretion. Sometimes this comes up, especially with management, when they have some level of discretion in decision making for the company. They made a mistake, results in their termination. That might be a defense you can use. Another thing to be careful of when you're an advocate of a claimant is sometimes employers will try and characterize poor work performance actually as misconduct. So it's something to watch out for. There is plenty of case law that says that if someone is terminated for poor work performance, that this does not necessarily disqualify them from unemployment benefits. I like to use an example from actually an advocate who's in our room right now who did a case for us. It was a hotel worker, and the employer said she was fired, she was insubordinate, she didn't follow my policies about cleaning the rooms properly. Wasn't cleaning the rooms properly work performance? We argued that and we were successful. She was allowed benefits because her failure to properly clean the room wasn't actually her being insubordinate, she just was careless. She was not a very good employee. The next topic that I want to talk about falls under Labor Law Section 591.2, capability and availability. This section of the labor law requires that a claimant must be, 1, capable of performing work, and 2, ready, willing, and able to work or to accept work. For the capability requirement, a claimant must be both physically and mentally capable of performing work. This type of determination, if someone is not capable or not available for work, typically arises after there's been some kind of injury, illness, childbirth, surgery, or some kind of temporary or permanent disability. Success and prevailing at a hearing may be dependent upon presenting relevant medical evidence. So if you have a client who was injured on the job, has a workers' comp claim, and they now are permanently disabled in some capacity, but let's say they're still available to do light duty work. You can present that kind of information to overcome a determination that they're not capable of working in any capacity. And the Department of Labor, it doesn't necessarily look at, are they capable of performing the last job that they held with the employer, but are they capable of working in general? For availability, a claimant must be ready, willing, and able to work and actively seeking work. Sometimes claimants are required to keep records of the job searches that they are engaging in, and you can encourage your clients to do that even if they haven't been specifically told by someone at the Department of Labor that they should be doing that. In order to be available to work, the claimant must be physically present in their local area, their local labor market where they're looking for work. If the claimant, let's say, is in jail, they're not available, they're incarcerated, they can't accept work behind bars. If they are out of the area or out of the country, this can also result in unavailability determination. If you are speaking with your client and they tell you that they're going to be away, they're going on a vacation, or they're going to be in jail for 30 days, I don't know, something comes up where they're not available to accept work, remind them that they should not be also certifying for unemployment benefits at that same time. Otherwise, it can result in problems down the road, a determination of willful misrepresentation possibly, if they're certifying improperly. The next hot topic is not totally unemployed. Total unemployment is a complete lack of employment on any given day. Problems in this area arise because claimants sometimes don't know how to certify properly. It especially comes up, well, sometimes you get a claimant who is just blatantly working at the same time as they're certifying for benefits. That's clearly problematic. But sometimes issues of not totally unemployed arise because they're working part-time and they're not certifying properly. The days that they're starting for doesn't correlate with the days they're actually working at an employer. Sometimes they work but they don't receive no pay, or they're volunteering. If you look at the claimant handbook, which as the judge said I would encourage you all to read, it's very informative. It gives very specific information about what constitutes work. Volunteering is included in that list of things that does constitute work. And I see some of you shaking your head out there.
Rachel, if I could interject for a moment.
Sure.
We do have a letter opinion indicating from, I believe it's the New York State Attorney General, that volunteer work for a not-profit, such as it doesn't say but, such as the Volunteer Lawyers Project, as long as you will take a job and stop the volunteering if it comes along, you can volunteer here and collect your unemployment benefits. But your first priority has to be, in order to take the job that comes up, you would say, well, I can no longer volunteer because a job opportunity arose. So do not let unemployment benefits dissuade you from taking a Volunteer Lawyers Project case.
Thank you. It usually arises because someone is not available during that time period they're claiming, or let's say they're volunteering at their religious organization and they're not actually looking for work. Those kind of things are problematic. Also, a problem that comes up frequently is if an individual is working, doesn't expect to receive compensation because they're working for family members or friends. I like to use the example of a hairdresser, stylist who's been laid off. They have a styling chair in their basement, and their nearest and dearest friends, family, relatives, neighbors, whoever, come over and they cut their hair on, Friday afternoon. Does that constitute work? Yes. Even though they're not expecting to receive compensation from that person. If you are in doubt about what constitutes work, look at the claimant handbook. I would suggest that you ask your clients to do the same thing, or try to call telephone claim center. Like any large bureaucracy, when you call the telephone claim center, the quality of the answers you receive will sometimes depend on who's answering the phone, and if they answer the phone. It can be extremely challenging to get through to the telephone claim center due to the high volume of people who are now flooding do get through to someone, or if your client gets through to someone, tell them to get some contact information for the people they're speaking with. So many times I hear, I spoke to someone at the Telephone Claim Center, they told me to do X, Y, and Z. Well, who told you to do that? Because that doesn't really sound right to me. I don't know, it was a woman. That's not really too helpful. If you can get a name, if you can get any kind of tangible contact information for this person, it might be helpful if your client relies to their own detriment on the advice that they're given by the Telephone Claim Center. That's not to say that there are not people there who are great. Sometimes there are really fantastic people that answer the phone. It just depends on who you get. So issues of willful misrepresentation. I just want to touch upon this briefly because we did talk about it a little bit before. A willful misrepresentation is intentionally making a false statement or representation in order to obtain unemployment insurance benefits that the claimant would not otherwise be entitled to. Essentially what it comes down to is that they lied to the Department of Labor, or the Department of Labor believes that they're lying. Some examples of where this might come up, again, is if you're not available, not capable, if you're certifying improperly for the reasons of your initial separation from employment. One of the defenses that you can use for willful misrepresentation is try to negate the intentional nature of the false statement. So let's go back to the example of your client's confused between discharged, let go, and fired. They didn't really understand what to certify for, even though in their explanation to the Department of Labor it has remained consistent throughout. That might be a way to negate that they intentionally made a false statement for how their employment ended. If an individual, again, is found to be guilty of a misrepresentation, they can be asked to repay their benefits, which leads us into overpayments and repayments. Clients who have received unemployment that they're not entitled to can be asked to repay, and they essentially become a debtor to the Department of Labor, which is a division, of course, of New York State. There are a couple ways that can satisfy their debt. One, they can enter into a repayment plan with the Department of Labor. I don't know how flexible they are in structuring a payment plan. It's typically not something that I've helped someone with, but they can enter into a payment plan. They can also enter into, or they can try to apply for a waiver of overpayment. This is available for some of the benefits that are available that claimants might be receiving. And they have to show that an extreme financial hardship would be assessed upon them if they were required to repay all of these benefits. I have seen a person successfully apply for a waiver of overpayment when they were a student and didn't have any source of income. But it can be an extremely challenging burden to meet, but it is something that's available. If someone, even if they have set up a payment plan with the Department of Labor, they may have their tax returns intercepted. And that is a nice way of saying that the state of New York is going to take your tax returns in order to satisfy your outstanding unemployment insurance debt. So let's talk about some practical information, some hands-on information that will actually help you as advocates in handling an unemployment insurance hearing. The first and most important thing, most basic thing, is your client interview. In the materials that are handed out, there is a very extensive checklist of things to go down and ask your clients when they come in for an interview. And I want to highlight just a couple of things for you now. You should remind your clients right from the beginning to continue their weekly certifications. So many times people come in and say, well, I was denied benefits, so I just stopped certifying. I thought that was, game over. No. They should continue certifying even if they're not receiving those benefits. So always make sure to remind them of that so that they're preserving those rights to benefits if in the future it's determined that they are eligible for unemployment. What I like to say for client interviews is that it's not about asking questions, it's asking the right questions. And unemployment cases are so extremely fact-specific that one small detail might change the entire structure of your strategy and the outcome of your success or failure at a hearing. One of the biggest challenges as an advocate, and nothing can be more devastating, is if you go to the hearing and all of a sudden new information surfaces through your client's testimony that you weren't aware of earlier. It might be damaging, or it might be something that's really helpful, and had you known about it, you could have done more research or changed your strategy to incorporate that detail into your hearing. And so many times, clients find details insignificant that we as attorneys might jump right on. So when you're asking questions, make sure you're looking not only background information, how long someone's worked there, their employment relationships, prior warnings, what's the employer rules or handbook, can you bring in a copy of your employer handbook to look at with me? Get background information, try and get the whole picture. What was your stress level like? Are you on any medications? Do you have medical conditions that might have affected whatever your cause for a separation from employment might be? Try and look at the entire picture as a whole, because then details that might seem minor to your client might trickle out. It's also important in your initial client interview to explain your scope of representation. Clients sometimes think that when they have retained an attorney, this is their big day to, a day in court. Make sure you tell them that your representation is just for an unemployment hearing. If you are planning to help them with an appeal, or if you're in private practice and you're helping them with something else, maybe it's a discrimination lawsuit, make sure that your scope of representation is clear to the client. We always say here that we're helping them with the local hearing, but that doesn't necessarily include an appeal, although it might. If they are looking for a private attorney for some other action, you can refer them to wherever you see appropriate, whether it's the Division of Human Rights or Labor Standards or lawyer referral service, whatever the case may be. But as long as your scope of representation is clear to the client, I think it might avoid any other pitfalls that might occur if not. One of the most important things in collecting information is reviewing the hearing file. There is the waiver that the judge is included in the judge's packets. There is also 2 single sheets that I included that we use here in our office, just a blank template of how we request a hearing file from the office. As was explained, if you are representing someone pro bono, you are entitled to a free copy of that file. Many times, because our office is so close, we'll fax over the information. A couple hours later, I'll walk myself over and pick it up. They can mail it to you too, but the office there, the staff, it's sometimes easier for them just to put it aside and have someone come and pick it up, depending on where your office might be located. Otherwise, there are fees that are associated with copying the file. I believe it's 25 cents a page, although I'm not positive because, again, we don't have paid fees here. When you're looking through the hearing file, there are some key things that you should be looking for. One of the best things to look at is a summary of conversation between either your client and the employer and the initial claims examiner. And how these files are compiled in the first place is through the telephone claims center. The initial claims examiner, who is investigating an unemployment insurance claim, will collect information from the claimant, from the employer, from other sources, and make the initial determination that we looked at earlier. And including in that file sometimes are a summary of conversations if the claims examiner has spoken to one of the parties over the phone. This can be extremely beneficial information because it will be a snapshot of what everyone is saying to the Department of Labor leading up to your involvement in the case. Also to look for are questionnaires, witness statements, notice of protest from the employer, any information on payments or certifications that your client has received or their certifications they've made, their initial certification when they claimed benefits, Sometimes there will be employer policies in the file, disciplinary history. All this can be extremely beneficial. Sometimes I like to say that I really don't know what's going on in the claim until I look at the hearing file. Not that I don't trust the clients, but they like to leave out certain details. Pay very close attention to the things your clients are saying to look for inconsistent statements. Look for something that might be illogical. Look for missing information. Maybe they told you something that stands out as the crux of the case, and that's not even mentioned at all in their hearing file. Why? Is there something out of step here? You need to do a little more investigating. Similarly, pay close attention to the things that the employer is saying. Employer witness statements can be both a blessing and a burden. Sometimes they can be extremely damaging to your case, but sometimes the witness statements are really helpful. We had a file recently where an employer said 3 different reasons as to why the claimant's employment ended. He was discharged because he had alcohol on the premises. He was discharged because he failed to show up for his termination meeting. He was discharged because he was a no-call, no-show. Well, those are 3 very different reasons. What was the final incident that led to this person becoming unemployed? The employer couldn't get it straight. We ended up being successful at the hearing because the judge in his decision found the claimant's employment ended for reasons known best to the employer. And sometimes that can be really helpful and will come out through the documentation found in the hearing file. I want to talk just very briefly about the research that's available. I think the best research tool is the Appeal Board Decision website. It's some of the best information. It's very up to date. The decisions that are on there go back to about like 2005, 2007 to current. So it gives a good snapshot of what the Appeal Board is ruling on right now. Westlaw and Lexis, not so fantastic. Our need to rely on these sources for unemployment cases is just not there. Really, it's used as a background for labor and employment issues, and some of the decisions from the Appellate Division 3rd Department are there, but the administrative decisions are not going to appear on a Westlaw or a Lexis. The VLP is in the process of developing our own research database. Right now, we're in the process of categorizing appellate decisions, appeal board decisions, local decisions, other hearing information into a system that can be searchable by topics, alcohol, tardiness, insubordination, etc. This is a work in progress at the moment. We're hoping by the summer it will be a little more formalized. But what is important about this, and if you are accepting a case through VLP, of course these resources would be available to you. The local decisions are extremely helpful. And they might give you a snapshot of the judge that you are having a hearing in front of. What are they thinking? What are the things that they look for? You're not going to find that information anywhere else. I want to talk quickly about some pre-hearing preparations. The most important thing, of course, is obtaining evidence that's not already in your hearing file. In administrative unemployment hearings, there is no real formal discovery process. And sometimes at a UIB hearing, you feel like it's trial by ambush. You walk into a hearing, there's a stack of papers this high, and there's a smoking gun right on the top, a signed confession statement by your client. And it comes down to the question of, should you subpoena these documents or try to subpoena documents in advance? If you are going to present or issue a subpoena for either documents or live testimony from a witness, the fees that are outlined under the CPLR are going to apply. For cases such as pro bono cases like VLP, our clients really don't have the resources to pay the fees under the CPLR. I'm not sure if that would be the same in private practice. I would imagine that if someone is paying you privately as an attorney, they might be able to afford some of the fees as well. But if you believe a document or a witness is going to be necessary at a hearing, you do not have to issue a subpoena in advance. You can go to the hearing, and if the judge also finds that document or individual is necessary at the hearing, they can issue a subpoena, request that the other party produce whatever it is you're looking for. If after a subpoena or a request has been made by the administrative law judge and the employer still fails to comply with that request, you can ask for an adverse inference. Sometimes that can be helpful. The next thing to do during your pre-hearing prep is to discuss your case strategy with your client. Talk about what information you think is most relevant and necessary and should get into the record at the hearing. It might help avoid irrelevant information, help your client stay on track, avoid these detrimental tangents they might go on in the hearing. And it sometimes helps to focus them, and typically I like to meet with a client a few minutes before going over to a hearing to try and refocus them and say, this is what's most important, make sure you talk about that when you're at the hearing. Also important is preparing some kind of outline or maybe some hearing questions before you go into the hearing, so you have an idea of what information you want to talk about, where you want to proceed. I try not to overly plan for a hearing though, because you never really know what's going to happen at unemployment hearings, and many times I walk out very surprised at what actually transpired during the course of the hearing. The next topic is credibility. It ends up being extremely important during the hearing process, especially in cases of a he said, she said. Many times it will come down to one employee against another, and the success of the hearing will rest upon who and why the ALJ thinks is telling the truth, who is more logical, who is more honest, and why. Credibility is so important to discuss with your client before going to the hearing, because it's not something that can be appealed to the board. There are some best practices that I like to go over with clients before we actually go over to a hearing, so that they can maintain their credibility during the course of the hearing. I try and review with the client their prior statements to the Department of Labor. These things might be contained in the hearing file. When they spoke to someone, when they filled out a questionnaire, what did they say, why did they say it, how is it different from what they're telling me now, where did this miscommunication come from and why. So talk about that, review their prior statements. If they're consistent all along since the beginning of their claim till now, then great, fantastic, you have no problem. That doesn't always happen. I also try and remind clients that they should avoid even minor inconsistencies in their testimony. So if the judge is asking them, how often did you do X, Y, and Z? They say at one time, well, I always did X, Y, and Z. A little bit later in the hearing, they say, well, I sometimes did X, Y, and Z. Those minor variances in their testimony might have a big impact on whether the judge believes they're telling the truth or not. Some other things that I counsel on are that their testimony should be clear, easy to understand. If a judge or someone else in the room doesn't understand what your client is telling them, they can appear to be inconsistent or insincere or illogical. So clarity is very important. I try and have clients outline a timeline of events. Sometimes that helps with their recollection of when things happen and the chain of events. Also, inappropriate answers to questions are problematic. Sometimes clients don't understand a question, they don't understand a word that's being used, but they're shy, they're afraid to say so. Reassure them beforehand that they are much better served letting the other party know that they don't understand what's being asked of them than giving an answer that's inappropriate and doesn't make sense. At the hearing, just a reminder, the administrative law judges will do the heavy lifting. They're going to ask the bulk of the questions. An advocate's job really is to elicit testimony that maybe the judge doesn't know to ask about, or to answer questions to clarify your client's, or ask questions to clarify your client's testimony. Hearsay, of course, is admissible. It will be given appropriate weight by the judge. Witnesses should be sequestered. Most administrative law judges will sequester witnesses right away. If that doesn't happen, make sure you ask for it. During cross-examination of the employer's witnesses, yes, of course, leading questions are appropriate. I like to use this time to test the witness's credibility. Many times it will go back to prior statements they've made, try to impeach them with something that either themselves, or someone else from their company has said to the Department of Labor. If it's inconsistent, that might be something to help you in the success of your hearing. Typical legal objections, of course, apply in administrative hearings. Try and inform your clients of this beforehand so they're not shocked when you stand up or you say something during a hearing objecting to a question. Sometimes they're caught off guard. The more informal setting of administrative hearing might lend them to believe that this is not a formal legal proceeding. It of course is, and legal objections are of course appropriate. If you have found case law that is particularly helpful to you, of course you can argue it in your closing. I like to sometimes also copy that decision, bring multiple copies for all of the parties, and present it to the administrative law judge and give reasons why they should rely on it in making their decision. Time deadlines, just a reminder, we've talked about these. You or your client has 30 days to request a hearing from the date of the initial determination. It's important that you always keep timelines in the back of your mind, because if you are not timely in following one of the various things, whether it's requesting a hearing or appealing to the appeal board, your case is going to be dismissed on procedure and the merits will never be determined. Again, another important deadline to remember, 20 days for the appeal, 7 days after you receive notice that the appeal has been granted by the appeal board in order to request transcripts. When the transcripts actually become available, you have 20 days from that date to submit your written submission to the appeal board. Does anyone have questions? Yes?
At what point does the client come to VLP for representation?
It depends.
Put it into this time frame. Is the 30 days pretty well gone by the time they get here?
Yes. Sometimes we get clients who say that they've received their initial determination months ago and never did anything. Typically, it's not something that you can actually help because they haven't met their timeliness requirement. Sometimes, when we get the whole gamut, we get people who haven't filed yet who call. That's very rare. Typically, the clients that we see have already filed, gotten initial determination, whether they're eligible or denied, have requested their hearing already. Then they call us. And the reason that's the case is because there's a pamphlet of information, and it's called the Organization's Attorneys and Registered Representative List. It's promulgated by the Department of Labor. Our organization, Legal Aid of Buffalo, appear on that list, and whenever someone requests a hearing, that list is automatically sent to them. So that's why I imagine we get calls during that time frame.
Rachel, I think it was before you got here, we've even gotten people who, called, made an appointment, they come in and I sit down with them and they show me a denial from 2 years ago and say, I was wondering if I could do anything about this. So it really does go the whole gamut. And of course, we wouldn't refer you that particular case.
A follow-up question.
Sure.
What are the criteria for a person being represented by VLP?
Volunteer Lawyers Project, we screen on financial eligibility. We accept clients here that are between 125, we like to stay between 0 and 125% of the National Poverty Guideline, which is set on the federal level. And it's based on the income and the number of people that are in your household. We have the latitude to accept someone as a client if they're at 200% of the poverty line, but not above. But typically it's 125% or lower. We would screen finances, and then we would also screen on the merit of the claim before we would accept the client here.
And those lines at the moment are?
For one person, it's like
13,800, I believe, for a single person living alone. If a client calls and says, I live with my parents in East Amherst, dad's an airline pilot and mom's a nurse at Roswell, but I don't have any money. Under our program, they're not eligible. Whether legal aid would take them, they might look only to what that person's income is. But our funding is per household.
We also look at how much cash is on hand. For a single person, they're allowed up to $1,000 in a bank each additional person is allowed another $500. So if you have someone come in that's a single person household and they say, I have $3,000 in the bank, they probably wouldn't be eligible for our services. Yes.
With regard to hearings, I know you're talking about direct examination and cross-examination, but what about the introduction of documentary evidence at the
Sure.
hearing?
Similar to any other proceeding, you can have something marked. You can show it to your client for authentication, then have it marked. The judge will determine if there's any legal objections, if there's any comments in any document, both from your side and the employer. One thing to know about hearings, at least for the hearings that we go to, many employers do not come in with counsel. It's usually a manager or someone from HR. Sometimes they'll have, this is one thing we didn't really talk about, there are a number of unemployment insurance third-party services. I think of Tulks or People Systems, so they're some of the bigger ones in the area. They sometimes have third-party representatives who administratively handle the processing of unemployment claims. So that would be sending in documents during the initial investigation period. Sometimes those individuals also come to hearings, and the ones who do come are relatively skilled. I'm not sure if they are all attorneys or not, but they too, would be able to enter documents, object to documents, things of that nature.
And so I guess this is maybe a form of question for you, but do you prefer when attorneys coming in, representing claimants or employers, bring additional copies of whatever exhibits, if it's something voluminous, so you have a copy to follow along as, questioning is happening?
Yeah.
Is that a preferred practice?
Yeah, that's important. If you do have documents that you're going to bring in, if you can copy them beforehand, copy for you, copy for the judge, and copy for the other party, that really helps out a lot, because the appeal board just recently has expressed an opinion on this, that they want everybody to be on the same page and to be able to see what the documents are that are being talked about. If you don't have copies for everyone, or if it's something that came up at the last minute and you bring in your only copy of it, the judge may be able to make a copy of it during the hearing. We don't like to do that because the hearing time is really compressed as it is, so we don't want to take the time to stop and make copies, but we can bring copies, that's great.
One additional comment to that, if you are unfortunately scheduled for a telephone hearing, which I think are sometimes very confusing, because you have the judge in one location, the employer someplace else, the claimant someplace else, sometimes the counsel's not even with them, trying to keep everyone on the same page. One of the things that are required when you're scheduled for a telephone hearing, that you send copies of documents you plan to use at the hearing in advance to each of the parties. Brett?
I have a question that's for Judge Oski. At the hearings where the judge might be doing the bulk of the questioning of your client, do you have any suggestions or recommendations for dealing with an ALJ that might be seeming a little difficult or aggressive with your client, kind of politely handling that situation?
I missed the end of that. Difficult or aggressive, and say.
Like when they're questioning your client and you feel like they're being a little difficult or aggressive, do you have any recommendations for politely dealing with that situation where normally you would object to another party that might seem like they're going out of line, but how would you deal with in an administrative hearing where you feel that a judge is doing that?
Well, you might ask the judge if the questions that you're asking, does he consider? You mean the judge is like stopping you?
No,
Is that what you're saying?
a judge is being particularly difficult with asking your client questions and seems to be sort of aggressive or hostile towards them. Is there a polite way to deal with that and objecting to the judge's line of questioning?
Oh, okay. Well, I don't know that you can object to the judge's questions,
Yeah.
but that's a good question. Rachel, you got any practical advice? Has that happened to you?
It has happened where sometimes it appears as though a judge might be almost truncating your client's testimony, where they start giving an answer and the judge will interject and say, well, why did that happen, before they've even finished their sentence. I don't really have a good answer for it though. There's not really much you can do, which is why I thought that'd be a good question for you.
You know, I will tell you, if you can express to the judge that, you know, your client is trying to answer the questions and could he have an opportunity to fully answer the questions. If you're still feeling that the judge is overly aggressive, you know, you can always call the senior judge after the hearing and say, hey, you know, I think the judge is out of line on this, here's what happened during the hearing. You know, we'll always talk to the judge and see what happened. You know, certainly people shouldn't be getting beaten up during hearings. So if you think that's happening, bring it to our attention.
Any other questions? Yes.
I was just gonna add to that a little bit, based on limited experience. I think it's very important to get some comment on the record to show that your client is not able to answer questions or something. So the way, I'm not sure there's a polite way of dealing with it, but I would get it on the record. If you're not getting your case across, if your client can't answer questions the way that you prepared them to or the way that they need to, you need to get it on the record. That'll go to, you know, if you do the appeal, that'll be part of the record.
That's another good thing to point out, is many times you wanna get information on the record that may not be essential, but to preserve for an appeal. Just always think about it in the back of your mind. Any other questions? Amanda?
I just wanna say, if you could just leave your evaluations on the table outside, and I also just need signatures from a Catherine and a Thomas. I'm kidding, really.
Thank you everyone for your attendance.
Yeah.